Very handy.
Order. Could I call the committee to order? This is the resumed hearing of the committee's inquiry into the European arrest warrant opt-out. We have given the Home Secretary and Parliament an undertaking that we will have our report ready for the consideration of the House by the end of October. Our witnesses today are Mr. Zalewski and Dr. Hart-Hoey. Thank you very much for coming. If I could start with you, Mr. Zalewski. Why is it that Poland has such a bad record in terms of the number of European arrest warrants that it's issued? I don't mean bad that they've done something wrong, but in terms of the sheer volume of cases that come from Poland. Why is that the case?
Well, Mr. Chairman, as always, these things are perhaps more complex than meets the eye, and it would be difficult to ascribe any particular one factor or some simplistic answer to the whole thing. But I've got at least 4 factors jotted down here, which may be of interest.
Well, if you could do them as briefly as possible,
absolutely,
I was grateful.
Absolutely. First of all, the actual function of the judicial authority and how it operates. And if I just extremely briefly quote Lady Hale, and this is a recent judgment that was delivered by the Supreme Court last year, and essentially a judicial notice was taken. This is a case of PHHH and FK, which was decided on the 20th of June 2012 by the Supreme Court. And there is a telling paragraph.
Is it a long paragraph?
No, just a sentence.
Telling.
Yes. I'm most grateful, sir. Furthermore, this is Lady Hale at 45. We can take notice of the fact that no prosecutorial discretion is exercised by the Polish authorities when deciding whether or not to apply for the issue of NEAW, no matter how comparatively minor the offences, how much time has elapsed since they were committed, and how respectable the life which the offender has led since then.
So Baroness Hale points
Lady Hale, yes.
Lady Hale points to the fact that there is a problem in terms of the process in the Polish judicial system that has led to such a large number of European arrest warrant requests.
So yes, in a nutshell, that is what it says.
Excellent.
I would agree.
And the other 3 nutshells?
And the other 3 nutshells, if I can put it that way, are sort of systemic differences. I mean, our judiciary in this country, if I can speak like that, are sort of incredibly good at trying to give effect to something which may at times appear extremely alien in terms of ethos.
Yes.
For example,
so they're very helpful.
Yes.
When somebody asks for a request, they just
absolutely.
grant the request. Okay, what is the third factor?
So generally, but what I was going to say is there is a literal interpretation of law in Poland.
Right.
We have over 300 rules of interpretation of a statute, for example.
Yes.
And it all depends on
so it's the
grammar.
interpretation of the law in Poland.
Yes.
What is the third factor?
The third factor, it's also the sentencing guidelines in Poland are at variance to what we expect in this country, for example.
Excellent.
It is very easy to get a custodial sentence over 4 months, for example.
Right. For minor offences?
For minor offences.
Like, for example, give me one example. We've heard about
theft
the
of a bike.
wheelbarrow.
Theft of a bike.
Theft of a bike.
Well, yes. Well, it could be.
The theft of a bike in Poland will give you a sentence of 4 months in prison. Yes.
It could do. It could do.
For a first offence? It could do.
As I say, everything is prescribed in statute.
Excellent.
And there is absolutely no movement in terms of discretion or anything.
And the fourth factor?
And the fourth factor, of course, also, that's more to do with this jurisdiction rather than the Polish jurisdiction, is the whole Schengen idea and how it operates. And of course, as you know, Chairman, we have not been part of this Schengen information system, for example, and also the fact that everybody can now travel with just ID cards, which is a great thing. A judge in Poland could not say, well, you cannot leave the jurisdiction, you've got to surrender your passport.
Yes.
Because an ID part is absolutely essential to exist.
Sure. So what you're saying is, if this European arrest warrant is kept, which the government wants to keep the European arrest warrant with a number of changes to legislation, this will still be a problem because we haven't changed either the sentencing guidelines or Polish statute or the attitude of the judges in Poland, which is to deal with strict interpretation. That is not going to change. So even if there are changes made here, it will make no difference.
If I may just say that, judges in Poland are doing their level best as well.
No, I know
but
that.
they're constrained.
Sorry, can you just answer my question?
No. Yes.
What's the answer?
Yes, I would say that there are fundamental problems which need to be addressed.
Which will not change.
Which will not change.
Dr. Hoing, in Germany, thank you. Dr. Hoing, in Germany, you have a proportionality test, which the Home Secretary is a great fan of. We'll come on to more of it later. Just in terms of the number of warrants that have been issued in Germany, do you have similar information to give this committee about the number of arrest warrants? We come on to proportionality later, and other members of the committee will ask about this. But do you have any figures about where Germany is in the league table of asking for European arrest warrants?
No, but I guess because Germany is very fond of issuing arrest warrants also at the national level, I guess it will be a great deal of arrest warrants.
And us, the United Kingdom, changing our position on the European arrest warrant and putting in a proportionality test, you're telling this committee, will not affect the German judges' decisions to issue these warrants since they're so fond of them?
Yes.
Thank you. David Winnick.
The question of the European arrest warrant is a very controversial issue, if not in Germany and Poland, certainly in Britain. And in Britain we have more controversy over, as you know, membership of the European Union itself. The argument in favour, as obviously you know, is that it's a very important instrument, the arrest warrant, in dealing with criminality across Europe. Critics say otherwise. What's your view about...
Dr. Silewski?
No, it's just plain Mr.
Oh, Mr. I'm sure you'll be a doctor at the end of the session.
I hope so. I hope so. Well, I like history, and I think history is quite informative, particularly in this case. Now, what we have here, essentially, and I stand to be corrected by Dr. Hart Henning here, who's probably much better at this than myself. But anyway, we have the impetus to actually put this through is the 9/11 attacks. And the whole criminality cross-border of a scale that was quite, I would say, the opposite end of the spectrum to minor offences. And I take it that the commission gets very bad press sometimes. They've actually produced a list of offences, a negative list of offences, which basically said, right, you will not issue EAW for X, Y, and Z. But that list, I understand, was then overturned politically. And now we have 32 offences, I hope I'm right, on the actual list, which are sort of the top-end offences, for which no dual criminality test is required. But then we have got a whole host of offences which still, for example, satisfy the 4 months, for example, on a conviction case, which fall below that. But anyway, as a tool, sorry to be long-winded, it is very useful. But again, I think one needs to think about the Schengen area and why the rationale why was implemented, because there were no borders in the Schengen area.
Can I it's really a yes or no on this one? Do you think that if the arrest warrant is changed according to what the Home Secretary has in mind, and if Parliament so approves, that it will harm or not the fight against criminality in Europe? Difficult?
I think that's probably difficult for me to answer, but in principle, I think it had to be done, because if one has thinking in terms of one big jurisdiction as a sort of Schengen area, then one needs to have a mechanism. I hope Dr. Honig agrees, which actually does what the European arrest warrant is supposed to be doing. because obviously transnational borders do not exist, and one has to have a mechanism by which one pursues certain individuals and brings them to book, as it were. Now, where we stand in this country, so far as that's concerned, well, that maybe needs to be looked at very carefully.
Thank you.
Your fellow witness told the chair that Germany is very uses the European arrest warrant quite a lot. Do you think if it was changed in the manner in which the British government has in mind, the same question I put to your fellow witness, it would undermine in any way the fight against crime?
I believe fighting crime effectively in the long run needs to heed the rule of law. And this concept of the European arrest warrant in many respects infringes the rule of law. So I guess in the long run, the capability to be a tool to fight criminality will fade away. What I know from UK, I will not try to do something on your home turf, is that there are improvements of a certain system. But I guess the essential question should be, needs the concept a remedy, and I guess a comprehensive remedy. Why? Because I guess the idea of mutual recognition based of mutual trust needs to be set right. Because the point is, there is no mutual trust, because there are no common standards, and I do not trust a Romanian or, Polish system. Insofar, what is needed to reconstruct, to put it this way, the framework decision and the concept in a way that these are building up trust, but we cannot rely trust because of the absence of common standards.
Thank you very much.
Thank you. Very helpful. Chris Rueda.
On this issue of commonality, I mean, what are the costs of a Polish citizen pinches a bike, steals a bike for £100 and then comes over here? The whole bureaucracy to get him back there may cost thousands, tens of thousands of pounds. Is there no proportionality that could be introduced? I mean, it doesn't show Poland in a good light if you are trying to take Polish citizens who have stolen wheelbarrows, drag them back to your own country. Is there nothing that you can do on the Polish side to screen those and say, this is reasonable, this isn't reasonable? Simple measure.
Yes,
as an English barrister, I find great difficulty in commenting on that in full. It would be a great thing to do, but insofar as the actual one needs to understand that this is a post-totalitarian era for places like Poland. I mean, they only just managed to start existing in 1997 when a new constitution was brought in. Now, things like judicial authority or anything to do in terms of judicial function, as we understand it, which has got certain aspects to it, is completely alien. The system did not trust an official. There was no room for manoeuvre, and that's how it's set up still, I'm afraid.
So you don't see that's going to change in the near
Well,
future?
no. I think there are moves, and I think what needs to be done, I think obviously judiciary cannot do it themselves.
Yes.
There needs to be a political movement in that direction.
Very helpful. Dr. Julian Hubbard.
Thank you, Chair. Dr. Al-Honig, can I come back to understand a bit more about the proportionality test in Germany? It'd be helpful to understand how it works for outgoing warrants, but also a word on your take on how that's fitted in with the wider European frameworks. I mean, essentially what I'm asking is, could we do the same thing?
The proportionality test, it starts is what is allowed and what is needed as a requirement for issuing a arrest warrant at the national level at the first point, because usually it's first a national level and then it just translated into a European one. And so it's a little bit what's proportionate, but we are also insofar not that good as I would like to, because, for example, it must not be expected a sentence without probation. It needs not to be one, and so it's also very low. But what we are doing now, putting it the other way around, if it's a proportionality test on incoming requests, We are only looking whether it's grossly proportionate. We are not substituting the judgment of foreign, that what the judge is doing, but if you believe it's grossly, some examples already mentioned, then we would say no.
I suspect we're using the terms in and out in the opposite senses. I think whether the request is coming in or the person is coming in.
Yeah, but, this way and the other way around.
But in terms of other states asking you have the proportionality.
Okay.
And that looks only for gross disproportionality. How is that defined? And have you had comment from other European countries about that? Have they resisted your introduction of that proportionality test?
Altogether not, because it's right under our constitution. So all judges, for decades, are trained in looking on proportionality. And it's now also enshrined in our International Legal Assistance Act, and it's also a European public order now. What's also part is proportionality. So far, if everybody takes it serious.
I mean, are there any other countries which take a similar approach in terms of requests coming in, people going out, looking at a proportionality test? Are you aware of other countries that do that? Are there any barriers that would stop them?
I would say you have, one is theory, one is practice. It's completely different. If you are looking at various, the practices of different higher regional courts, it's completely different. Some are just taking a formalistic approach, doing more or less nothing. Others are taking it quite serious. And there's no appeal because the higher regional court, just the blue heaven, is above.
Yes.
Unless constitutional court. But they are not doing such tests.
Thank you. Dr. Huppert?
But would you suggest that we follow the German model for this? And should proportionality tests be conducted by the issuing state or the receiving state?
My suggestion is including in provisions, not as a general rule, look for proportionality. What should be included is, for example, it is not allowed to request for the enforcement of a sentence that it's not higher than, say, 1 year or 2. If it's just discretion, I'm really concerned the practice will just continue.
Yes. But anyway, you've told the committee already that even if we change to a proportionality test, it would not affect Germany, because Germany would still be requesting.
That's right.
Because they're very fond.
There will be no impact, I guess.
Indeed. James Clapperson.
Well, thank you very much. It's been extremely helpful listening to your answers and listening to some of the questions. I have to say I'm tempted to the conclusion that people who support the European Union in these matters are prepared to throw civil liberties out of the window and just let the EU juggernaut steamroller justice and all the individual nation states. And listening to what you've said, wouldn't it be simpler if we just had individual agreements between different nation states in Europe, as between England and the United Kingdom and Poland or Germany, and we could build up the mutual trust which you've talked about, rather than having a one-size-fits-all solution dictated by the European Union?
Well, at times like this, I wish I was a politician, but I'm not. Yes, absolutely. I mean, in a sense, one could argue. One could argue that is the case, but of course, one needs to be fair in the sense that, for example, the Schengen Information System, which I understand the government is putting in October of next year, is well overdue.
Yeah.
Now,
we know about the Schengen Information System. Mr. Clapperson has put to you this point.
And as an English lawyer, I must agree with him.
You agree with him?
Yeah.
You think it's better to bilaterally negotiate with 27 countries? Dr. Honing?
Either yes, or it's a European Union of different speeds. And so, as it's discussed as to the currency, maybe there are a couple of units where I have more or less trust, and there are others none. So it could be also multilateral, but I guess it's premature to have a one-size-fits-all solution.
One other point on this, were people subject to an arrest warrant are concerned at their potential treatment after they've been extradited, to what extent can they use the European Convention on Human Rights to prevent their extradition? We took some evidence yesterday from people who, after the alleged offences had taken place, had returned to this country, and then they'd been extradited, and they were very worried as a result of what had happened to them at the time of the alleged commission of the offences, the way in which they've been investigated, the way they've been dealt with, the lack of interpretation, the lack of justice, the lack of opportunity to put their own case. They then come back to this country, and later on are extradited back.
Yeah, but this convention is a very nice convention. The point is, first, if you are doing remedies, going up the ladder through all the remedies needed, it takes you years. So in this regard, you can just ignore it. In Germany, it has not something like a constitutional status. It's considered something like a federal law, just a convention, but the Constitutional Court has found a way to construe our fundamental rights, to put it this way, in the light of the convention.
Thank you. Thank you. Michael Ellis and then Dr. Hubbard.
Thank you, Mr. Chairman. Well, gentlemen, I'm reminded, listening to you, of the old saying by William Blackstone, I think in the 1760s. It's better that 10 guilty persons escape than one innocent suffer. You've heard of that,
of course.
That very famous saying. And the reality,
worldwide,
the reality is it not, that part of the defect in the European arrest warrant system is that it seems actually to disregard that principle, inasmuch as when you apply a one-size-fits-all protocol, human beings don't tend to fit a one-size, human scenarios don't tend to fit that protocol. And that we get manifest injustices like those this committee has heard about. That clearly is of great concern to those who are interested in civil liberties. But do you think that the proposed reforms will have some beneficial effect to that? For example, the issue of proportionality, isn't that rare? My understanding is that we have that proportionality test the United Kingdom does with other countries already, the United States, for example. So we don't extradite people to the United States unless the likely sentence is 12 months or more. Now, wouldn't it be quite simple to have a system whereby, unless the gravamen of the offence is one likely to be met by that type of sentence in this country, it simply isn't worth sending them?
Would you like to answer that question? Do you know what the question is?
Yeah,
yes,
of course. I guess just, for example, a proportionality test will change nothing. I guess the problem with the presumption of innocence is that what is required as a strong suspicion is a very dynamic, blurred phenomenon. At the very beginning of an investigation, it's close to nil. Close to bringing charges, it's very high. That means the same word is at the very beginning low. That means you often see arrest warrants issued when it's just the police protocol and a certain idea of the case. So what is needed is, for example, I guess that's your system, extradition is only allowed if it's at the pre-charge stage.
Past the pre-charge.
Or even past pre-charge, because otherwise you have this wide area that's far from clear how robust, how lasting the evidence is.
Right, thank you.
Mr. Walewski?
I was just going to say two things. One thing is, I think extradition may be easier to live with if it was just to do with the 32 really major offences, and that the rest will be taken care of in some other way, for example. So in that way, that might be a good way of dealing with it. But also there may be a greater cooperation, for example, insofar as the lower end of the scale is concerned, between the probation systems in Europe, which is completely missing. And also another force that has been taken out of the equation is the politician, which I think might be a good thing, because politicians can actually be accountable, as number one, to hold the balance to something or make sure that something is in check. So all that's been taken away.
So are you suggesting that at the end of the day the Home Secretary should make these decisions?
Well, she does it, no, but she's part of the equation as it were, which may be balancing the whole the system out.
There's a political dimension.
No, absolutely. But the thing is, what I'm saying is, I would loathe a system where judiciary was being pushed to make political decisions.
Yes, Mr. Ellis.
If that were the case.
But what the couple of the remedies that have also been spoken of to improve the system that currently exists with the European arrest warrants is to permit the issuance of bail for those people pending proceedings. So if they're going to be extradited to Poland or wherever and potentially spend months or even a year or two in jail pending proceedings, that clearly can lead to a manifest injustice. If they're permitted to be on bail as part of or if bail is at least possible, then that may reduce the injustice if they later go on to be acquitted. Would you support that?
Dr. Hoening?
But only if this bail is granted on the home turf, or type of bail that they can return until the proceedings take place, because if they are deprived from all this social environment, the damage is done.
Yes, I accept that. Thank you very much, Chancellor.
Mr. Zalewski?
I would second.
Thank you very much. Dr. Hubbard, there's a quick supplementary as we move on to Bridget first.
Thank you, Joe. I just wanted to follow up from Mr. Clapson's question. I think he was advocating the creation of some 351 bilateral treaties to deal with the alternatives to the European arrest warrant. But do you think there's any reason to be certain that such bilateral treaties or return to the pre-existing Council of Europe approach would necessarily be better from a civil liberties perspective than a European arrest warrant, if reformed as the Home Secretary has suggested, and perhaps with a proportionality test, the forum bar and various
provided the parties are sharing common standard in a substantial way?
Thank you.
Mrs. Zalewski?
I agree. Bridget Phillipson.
Just one other point, Chair. Regardless of the means by which you would extradite or otherwise, is part of the issue not around the lack of speed in proceedings in some member states? What we heard yesterday was the length of time it can take for cases to come to court, and certainly I've seen that in constituency cases where it can take 2 or 3 years. There's very little the British government can do, because if that process applies equally to Spanish citizens in Spain, a British citizen isn't being disadvantaged by that length of time, but clearly they are, because it requires them to reside in another country pending the outcome. What more can be done to just speed up proceedings in some member states?
You're speaking about the proceedings, the regular ones, not the extradition proceedings.
Because it appears to be connected as well to the length of time it can take for the legal process to...
I guess particularly I'm only doing white-collar crime and tax-related crime. If you have a very complex cross-border case, it just takes years.
Yeah.
And it's more or less no chance to obviate these problems. So it's just about, because presumption of innocence, again, you have to have a bailout system in place, what works and what will keep the guy who has to be seen still innocent in his regular, natural environment. The only solution.
I agree. I don't think I can add any more. It's sort of a fundamental, universal point.
Just some of the cases I've seen, it can take 2 or 3 years for a trial to come, case to come to court, and in that time you're prevented from returning to your home country. It seems like
investigations in white-collar crime proceedings sometimes take, the longest I have taken, it's more than 7 years.
Okay.
Just the investigation.
Thank you. In terms of training, do you think there's a role for training in, to what extent that could be improved in member states in exercising the European arrest warrant?
Who needs to be trained? I guess the German officers are well trained because they specialize, the prosecutors specialize in extradition issues. Who needs to be trained are lawyers, because they have not the UK legal aid system, and if just one, they have just no idea. They have no time to start working on it. So if someone needs to be trained, then it's the lawyers.
Would you like to add anything?
Well, as Dr. Hennigs just said, we do have a legal aid system. We are extremely lucky to have one. But equally, I think people need to, as my head of chambers have always said, the primary duty is to the legal aid board in running of those cases, particularly appeal cases. And one has that at the forefront of one's mind. And sometimes one has to say to the client, I'm sorry, you've got no merit in your case, and that's that. But luckily we do have quite a few lawyers who are very, very good at extradition. Of course, there's the dedicated extradition unit here.
Is there therefore any solution to that? Because that's unlikely to change. So would training lead to any improvements, given that we're not going to alter the fact that we have a legal aid system but some member states don't?
You must understand how there's huge difference in legal aid systems. In Germany, you can earn in the period of investigation at a maximum 6,000 euro, not per day, for the whole period. It takes 7 years for 6,000 euro. If you have a long-lasting extradition case, nobody can afford it. That means the guy who are working just on an hourly fee basis, what I do, you need clients who can afford it. Most clients cannot afford it just in the petty offense, so they are coming across that's not against these colleagues, but they cannot afford to be trained to know this very complex extradition law. That's just what it is.
Thank you.
Thank you. Lorraine Fulbrook.
Thank you. Could I just ask a supplementary to that? As well as lawyers, is there not a case for training the police in member states as well, when they actually make arrests for, if you like, spurious cases, traffic offences, for example? I mean, is there not a case for police training too?
Yeah, but police, at least in Germany, have nothing to do with the extradition matter.
But
it will be only prosecutors.
What about charging in the first place, though?
We have not that system. Sorry. We have, from the very beginning, from the inception of the case, also if the police starts actually, it's controlled and supervised by prosecutors.
Yeah. Is that the same in Poland?
Well, I'm not a Polish lawyer, but
No,
I can only comment from my experience of Polish cases in the UK. I would rather think that the system has been borrowed from Germany, the way Poland's operating in terms of law and stuff like that. So essentially, I would probably say that it's very likely that the Poles are operating on the same principle. And also, there's no legal aid. There is, we take things for granted. For example, we have a lawyer in the police station in a cell, etc., etc. Nothing like that happens in Poland. Again, a lot of judges have expressed concerns with regard to that, and of course, so there is a huge difference in between jurisdictionally, particularly insofar as this country is concerned, and our other states in Europe, such as Poland and Eastern Europe, Central Europe.
Thank you.
Thank you very much. Final question from Chris Ruane.
The evidence we took yesterday from British subjects who've been extradited to I think to Portugal and Greece, and from the evidence we heard from you today, things aren't working well. Things can be improved. In what way or what actions could the British government do to improve the procedure here in the UK, and what actions could it take to improve procedures at a European level?
I'm not an expert to advise on what the UK should do. I guess the only one, if it's about your law, I do not in this regard, and given the majority of this stuff, rely on principle-based approach. I would like to have crystal clear criteria. For example, you mentioned Greece. You can get 10 years imprisonment for just one part of cocaine, very small as a consumer. And so it's what needs to be, it's clear criteria, what you are going to surrender and where not. Again, that's the point. And other than what's now maybe in Measure C Part 1, what just has passed the European Parliament yesterday, you need to have dual representation. That would be requested for a long while, and maybe now it's not yet implemented. We'll see how it will work out practically in all the countries.
Thank you very much.
Sorry, I was just going to say just a couple of things.
Yes, of course.
One thing is that perhaps other agencies cannot cooperate. I mean, we have a lot of cases, for example, which probation in Poland are recalling and issuing extradition warrants for, which are very minor offences. For somebody who perhaps did not get in touch with the probation or left and got a job here and so on and so forth. Now, if a judicial authority as a concept is a thick concept and is a very wide meaning, then basically perhaps probation in various member states can cooperate with each other, so that perhaps EAWs are not issued for, say, breach of probation. I had somebody who ran a case in a tribunal for not being invited back into the UK, first-tier immigration tribunal, who had a letter from probation in Poland saying that he's perfectly at liberty to go to the UK and work there, as long as he kept in touch with them, for example. So I think if there was more, for example, on a basic level, outside of the 32 offences, if there was some cooperation between the probation systems, then a whole host of EAWs could be avoided at the stroke.
And then finally, will the European investigation order and the European supervision order reduce the level of demand for arrest warrants?
I fret about this. I guess this will not really be of a significant impact, because it's just about minimizing or the measures which are provided for in this instrument, the supervision order, is something that leads in Germany to a suspension of the execution of an arrest warrant. But the arrest warrants are usually based on grounds of risk of absconding. So there will be no remedy in this regard. As to investigation, that could improve given the Polish cases, because it's often just about interviewing suspects.
Yes.
And they're issuing an arrest warrant. In this regard, maybe.
Indeed. I'm going to ask you both, as a final question. You're both very distinguished lawyers. You know this subject matter very well. You looked at the Home Secretary's list. You know the task that we have been set, along with the Justice Committee and the European Scrutiny Committee, to prepare a report for Parliament. So this is serious stuff. A lot of members of Parliament are going to be reading our report and making their decision as to how they're going to vote on the basis of what this committee says. I want a brief answer from both of you. Having looked at the list of 100 measures, including the 35 measures that the Home Secretary wants to opt in, do you think we should support this list? It's your opinion I'm seeking. Or are there still problems with the 35 that we're going to opt into, including the European arrest warrant? Mr. Zalewski.
Well, it's very kind of you to say that. To be honest, I find it difficult to come to a definitive view. But European arrest warrant is definitely an area that needs to be examined in some detail. With regard.
So you're not happy with opting back in, even with the 4 safeguards that the Home Secretary told the House about?
Well, I think this system, and I've always been impressed with it. It's based on something that works, rather than an idea plucked and perhaps fashioned from something and then being made to work. And if that pragmatic approach is adopted, and sometimes it takes longer, wait and see, then obviously I would be in favour of that. But obviously...
You're sounding like a typical lawyer. Now, I know you've got divided loyalties. Yes. I know you've got divided loyalties, and England will be playing Poland on the 15th of October. But do you think that we should opt into the European arrest warrant as currently drafted, with the changes that have been elegantly proposed by Theresa May?
So I would say that...
A yes or a no would be helpful.
It's very difficult, but I think more work needs to be done, I think.
More work, so no at the moment?
Not at the moment.
Not at the moment. Ms. Dr. Hart-Hoeing, can you
It's better with the safeguards than without, but I would not vote for opting in.
You wouldn't? No. Thank you very much. You've been both extremely helpful. We're now going to hear from the Cabinet Minister who negotiated the opt-out, Charles Clarke. You're welcome to stay in the body of the hall if you don't have to rush back to court. But thank you very much for your extremely helpful evidence.
Extremely grateful for being invited. Thank you.
Thank you. Could we call Charles Clarke, please, to the dais? Mr Clark, welcome back to the Home Affairs Select Committee.
Thank you very much, Mr Vaz. Very nice to see you again.
We are most grateful to you for coming here. The context of this is that the Home Secretary, one of your successors, has asked this committee to look at the measures that she's proposing to opt in and opt out of, and she's asked us to deliberate to prepare a report for Parliament by the 30th of October, along with the Justice Select Committee and the European Scrutiny Committee. We've asked you here because you are the Home Secretary who has enabled us to have this discussion, because you negotiated the opt-out. If I could start by asking you, why did you do that?
The sequence of events is not actually quite as you described, Mr Chairman. I finished as Home Secretary in May 2006, and the European Council under Angela Merkel, the German presidency, decided in June 2007 that it was going to set about the process of establishing a further renegotiation of the Lisbon Treaty. That followed a declaration in Berlin on the 25th March 2007. Following the European Council, the Intergovernmental Conference started in July 2007, and the treaty was then signed in Lisbon on the 13th of December 2007, and as we know, came into force in December 2009. So I was aware of the run-up to the conversation, but I wasn't in office at the time of the process when the British government was actually deciding its views.
But did you support the view that we should opt out?
I didn't actually, no. I felt that the opt-out was suggested by those who were more anti-European in the government, and there were some at senior levels in the government, because they wanted to keep open the possibility of not being as engaged in the Justice and Home Affairs pillar as we, in fact, subsequently agreed to do. And I think the reason was entirely political. It wasn't about Justice and Home Affairs, law and order. It wasn't about how to best deal with the threats from international crime and so on. It was because of the difficulties, the political difficulties, which you as a former Minister for Europe are more than familiar with, of getting issues of this kind through this Parliament, both houses of this Parliament. And by having the opt-out in place, it gave the possibility that people could say, if we don't like it, we could return to it. But I don't believe there was even at the time it was carried through, any view that an opt-out was a worthwhile thing to do. Still less do I think there would be any intention.
You would prefer us not to have opted out, and you certainly don't like the idea that we're opting out of any measures, because in an interview with Justice Across Borders on the 22nd of January, you said that opting out and then attempting to opt back into 35 measures will universally weaken our ability to fight crime and is a terrible idea. Whereas Yvette Cooper, of course, I'm not saying you should agree with everything she says, says that actually it's good to opt out of some of these measures because they're obsolete, they do not exist anymore.
I think that the opt-out was a terrible mistake by this government. And I think the Labour Party,
by your government?
By the current government, by the current coalition government, and I think that the Labour Party should have taken the position of opposing the opt-out from the very beginning. I think there are no benefits in the opt-out to preventing crime. The biggest threats we face, serious and organised crime, drug dealing, people trafficking, illegal migration, fraud, internet crime, terrorism, are all international. All of them require close cooperation between police and security organisations, and close cooperation between justice organisations, for example, in the form of the European arrest warrant, to bring people to justice. And I believe that the best way to fight this international crime is to strengthen international cooperation rather than to weaken it. I believe that the reasons why this government has decided to do this are entirely political in relation to the attitudes of the European Union, and not at all about law enforcement. That view has been strengthened by the announcement by the Home Secretary of the decision to seek to opt back into 35 measures, including the European arrest warrant, which I think give very little even potential benefit at all from those who think there is some benefit in opting out.
So you don't like you looked at the list, you think 35 is not enough. Obviously you don't want to opt out in the first place, but if we were going to opt back in, since that your government of course gave us the chance of opting out, you'd like to go back to all 135?
I think that and I know this from a number of conversations, that the Commission would agree, and I think many in the European Union would agree, that 133 is far too many, and you can get to a position of, say, 35, 40, 50, and I think you can do that perfectly well by agreement. I don't think you need to go through this opt-out process in order to get there.
Sure.
I
That's
think
very
that,
helpful. Thank
okay,
you. We just have a number of colleagues that I'm going to call David Winnick. Dr. Huppert, Mr. Clapperson.
Thank you, Chair, and welcome, Mr. Clark. And I read in the EDP that you're moving to Cambridge, so I look forward to
I'm going to be one of your constituents. I'm afraid that I think I'm unlikely to vote for you, but that's not because I don't regard you as an excellent member of Parliament.
Thank you very much for that praise, which may appear in literature. It's very good to hear your comments about the problems with the opt-out in the first case, and I do agree that it would have been helpful had the Labour front bench said that we shouldn't opt out in the first place. It felt very lonely for those of us who were arguing that. But we are where we are. Do you think that the effort that's been taken, both from the police perspective, from a parliamentary perspective, from a government perspective, from all the officials who've worked, and the negotiations that will happen in Europe, in order to deliver an opt-out and opt-in, would have been worth it at all?
In no respect whatsoever. I see no gain and massive potential risk. I didn't respond to part of the Chairman's earlier question about the risks involved. I think it's not at all clear that we will be able to opt in the way that is proposed by the government. I think it's quite likely there'll be egg on the face in a very substantial way for this whole process. And the fact that there's required to be a parliamentary vote in both houses, I think also means that if there is any doubt about the actual implementation of the opt back into the 35, there's a serious possibility of the government being defeated in one or both houses, in which case the whole issue would be would have been a total disaster. As it is, it simply would have been a waste of time to no value whatsoever.
Thank you. Mr. Clapperson and David Winnick.
Can I say to Mr. Hart, welcome back as somebody who's on the committee when you used to come and give evidence to it, and you were always very frank and very honest when you were giving evidence before and left nobody in doubt as to your position, and you also, if I remember correctly, had at one point to frankly take responsibility for something which wasn't your fault at all, if I remember the circumstances correctly. Can I take you back to the background to the decisions which were taken? Were you the Home Secretary at the time of the Constitutional Treaty proposals, which
yes.
was the predecessor of the Treaty of Lisbon?
Yes.
Great Britain or the United Kingdom wasn't. Am I correct in this? Was not going to be. Our membership of the Constitutional Treaty was subject to a referendum promise. Is that
yes,
correct?
Yes, it was.
And at that time, the Constitutional Treaty proposed that the United Kingdom would be part of the Justice and Home Affairs chapter of that treaty. That's
yes,
correct,
yes,
isn't it?
Yes.
And one of the reasons which was given for saying that the Treaty of Lisbon, the subsequent Treaty of Lisbon, was different from the Constitutional Treaty was that the United Kingdom was not part of the Justice and Home Affairs chapter of the Treaty of Lisbon.
That's one of the reasons it was given, yes.
Thank you.
Thank you, not Doctor yet, but David Winnick.
No, not Doctor. It's like old time. You said in effect, in reply to the chair, but this is really political, and would it be therefore right that regardless of the technicalities, we're examining a number of witnesses who are very proficient, to say the least, in European law and aspects of the European Union, but the attitude one takes politically as politicians over the opting out or opting in depends to a very large extent on one's attitude to continued membership of the EU.
I think that is true, but there's an interesting qualification which has surprised me. Another classic political issue upon which you in your own life have been very active on in the discussion is on the security, liberty, the crime prevention argument. And I'm surprised that this issue has been dominated by the politics of in or out of the EU, as you rightly, in my opinion, suggest, and less preoccupied with the effectiveness or otherwise of policing and justice measures to coordinate to contest international crime. And that's also a political issue which has often been there. But I think your analysis is completely correct, that the dominant question has been in or out of the EU.
Do you think to a large extent the present government are doing this to appease, if that's the appropriate word, the anti-European element, be it in the government party at the moment, or generally in the country where, as you will admit, no doubt, there's a good deal of hostility to continued membership of the EU?
I do believe that's the case. I do believe this particular decision wasn't thought through, and I think there are many people who haven't understood the consequences of this. The consequences will be reduced if we do succeed in opting back into those 35 measures, which is the bulk of measures in which are in our interest. I think there are others which it would be beneficial to come back in, but the key 35 are there, including the European arrest warrant. But if anything went wrong with that process, I think there are very, very serious consequences indeed. I chaired a session held by a think tank about the implications for the Irish relationship, for example, where a former Irish ambassador to this country made very powerful and strong remarks about the dangers for security in Northern Ireland of this issue going wrong in some respect. And I think people haven't thought it through. They've just gone to the knee-jerk politics rather than considered it fully.
Two further brief questions. Clearly then it's your view that opting out, be it the European arrest warrant and other aspects, would undermine the fight against criminality in Europe?
Absolutely, and very strongly. As I say, the secular trend, which I observed very closely both as police minister in the late 90s and then as Home Secretary, is of the increasing internationalisation of crime. Syndicates which are organising, for example, people trafficking, for example, drug dealing, and they impact directly on our streets. It used to be the case, for example, that 75% of the heroin in this country came up through Kosovo, for example. And the question of how you can test that and deal with that is an extremely important issue, including in terrorism issues as well. And that requires the police to cooperate very effectively. It also requires judicial cooperation, as in the European arrest warrant, to bring people to trial in the most effective way.
Mr. Clark, you're a very senior former politician, and you've certainly not given up politics. You've emphasised the political aspects, and I'd ask you questions on that. My last one really briefly is this. You've spoken about, in answer to my question, the government party. Would it be unfair to say to a very large extent that you represent on this issue, if nothing else, the Blairite view of the Labour Party towards the EU?
I reject the word Blairite. I always have. I think I went so far as to write an article in the New Statesman to think it was not an effective and accurate definition of somebody's political position. But I certainly wouldn't claim to represent a majority view, and I certainly would claim to be more pro-European, if I can put it like that, within the Labour Party than is the current centre opinion within the Labour Party. And I regret that. I think it's, in fact, I think our future comes through more cooperation, not less. But the arguments around this aren't only about the European Union. They're also about the extent to which we cooperate internationally in fighting crime, not only in the European Union. Obviously, it's a very important component, but it's wider than simply the EU.
That's a very frank and honest answer. Thank you very much.
Thank you. Michael Ellis.
Well, thank you, Mr. Chairman. Well, Mr. Clark, you've made some political points in your evidence so far, and I was just wondering, you confirm, of course, that it was Labour that gave this country the option of opting out in the first place, was it not?
Yes, it was.
So you're complaining now, are you, that you don't like it, that exercise that your government gave is now being undertaken?
Well, it's not required that it be undertaken. The opt-out is an option. And the Labour Party gave the option in the negotiation for the treaty, and that was an option which is open to the government now.
But you've been rather dismissive. It was open to any
government up to 5 years. It was not a requirement, indeed a suggestion of the last Labour government that anybody should actually take up that option.
But you've been rather dismissive of suggesting that it really must all be about politics, that this opt-out be even considered in the first place. But surely you would have to accept, and I think you went some way towards doing that just now in an answer to a question from Mr. Winnick, that there are actually some Labour voters who are also sceptical about Europe and its powers and the way that those powers have developed. Would you accept that?
Of course.
And effectively, you have a personal player in the game, if I can put it that way, and that you're the person who was Home Secretary when these powers were negotiated, and you don't like the idea that they now be resigned from.
Well, I don't think that's an accurate description at all. I was a personal player in the game. I was a pro-European member of the Labour government. I was in the cabinet at the time of the referendum which Mr. Clappinson asked about earlier on. I didn't think that we should have had a referendum at that time, but I lost that particular argument. We shouldn't have put that forward in my view. And I have a set of views about this. But the central question for this discussion isn't really about the pro or anti-EU point. It's about what's the implication for fighting crime and reducing crime for the people of this country.
Yes.
And I think that should be the top consideration. So just to be absolutely clear, If I were clear that opting out of a number of these measures would improve this country's ability to fight crime, I'd favour it, despite my generally pro-European stance. And my regret is that the debate has taken place such as it has been on a relatively narrow political basis, pro-anti-EU,
well, I understand that.
rather than law and order.
So can I come to that point? And I presume you would accept that innocent people are also entitled to justice.
I do, funnily enough.
So, of course, and so, because I made that point, because you've spoken hitherto, in answer to questions from my colleagues, about justice being affected by those who have done wrong, by being punished for what they've done. And I don't think anyone in this room would disagree with that. But also, a balance has to be drawn, does it not? And this is always the political question that has to be dealt with. A balance has to be drawn between that and achieving the ends of justice without being unjust to innocent people.
Of course, what I
do not accept that there are serious fundamental flaws within the system as it currently exists that have led to manifest injustice for innocent people.
You can only be referring to the discussion about some aspects of the European arrest warrant having been used in a disproportionate way by some countries. That particular narrow question is a fair point, and I think it is true. It's one that's accepted by many people throughout the European Union, including by the Commissioner concerned, Madame Reding, and there's, I think, a general consensus, and I've talked to a lot of people about this, of a readiness to make reforms to try and reduce what I'll call the disproportionate use of the European arrest warrant that some countries have engaged in. And if that was your banner, I'd be behind you. I think it's a correct thing to do. But that's not, in fact, the banner which this opt-out's being fought behind. The banner is, let's chuck out the European arrest warrant and everything about it.
No,
I'll tell you, well, perhaps I won't. If you invite me to tell you a story about it,
very briefly,
I will.
But
I don't think that's right.
Final question. I think you're done, Mr. Ellis.
I think I am.
Let us... Oh, well, sorry. Is it a long story?
I can make it particularly short for you.
Excellent.
There was a long case of a man who was accused of placing a bomb on the metro in Paris, and he couldn't be extradited from this country to Paris to face trial. And I, as Home Secretary, had to deal with the Minister of the Interior, Monsieur Sarkozy, to discuss the question of how we could get this done. And the only way it could be done would be if the French government would come to the British court and say in court that the individual would get a fair trial in Paris, in France, which the French governments traditionally had always refused to do because they thought it was beneath their dignity to go to another country to say, well, we actually do have fair trials in France. And so this case had gone on for literally a decade. And eventually I persuaded the French minister to send somebody to the court in order to make that case, which he did. The man was then extradited and then had a fair trial. My point about this little story is that process on a suspected terrorist had gone on for over 10 years and didn't have any process, precisely because we didn't have a European arrest warrant or anything of that kind.
But isn't the answer that has been put by those who are concerned about the European arrest warrant to negotiate those bilateral treaties with individual countries? And if we had such an agreement with France, the bomber would then have been able to go. It just means a little bit of hard work, but you can get all those agreements in place, can't you?
One of the terrible misjustices which occurred when I was Home Secretary, if you went to the extraditions unit in the Home Office at that time, you had a large number of cases which were just hanging around for literally years and years and years because such agreements hadn't been agreed, including with countries within the European Union.
But they can be, if the countries want to do it.
Well, if they want to, but the European, that's why the European arrest warrant, which was signed when I was Home Secretary, was such an important advance. And of course the classic case is the one you're more than familiar with, of the suspected bomber a fortnight after 7/7 who was arrested in Rome under that process.
Indeed.
Or again, you've got the whole of the Costa del Crime process where we had all of those issues.
So your view is it will take too long to get these treaties
much too long,
negotiated?
and it won't happen.
Steve McCabe and then Mark Reckless.
I just wanted to ask about Mr. Ellis's concerns about the European arrest warrant, and I wondered if you thought that the proposal for the European Supervision Order would go quite a long way to addressing some of his concerns without the need to opt out and take the risk that you've been referring to.
I think it certainly does, and there was a time when I was worried that the government wasn't going to work with the European Supervision Order. I'm delighted it has, and I completely agree with your analysis. I think it does go some way towards dealing with it. I also believe it illustrates what I said in answer to an earlier question, that there is a willingness within the European system to re-look at some of these questions to try and deal with some of the problems that there have indeed been.
Mark Reckless.
Mr. Clark, you were saying earlier that you foresaw a risk of a proposal to opt back into a package of measures being defeated in one or both houses of Parliament. And I just wonder if you could explain a little more of what considerations might apply and why you think that.
My greatest worry is that that opt-ins won't be agreed in the European Union. They have to be agreed by unanimity, as you know, and any European government can simply sabotage any of the opting backs in for whatever reason. And unfortunately, one of the worst aspects of the European Union is the horse trading that goes on all kinds of issues. And what prices will arise, we don't know. So, for example, the Spanish could say, we won't agree to all this happening unless you do X or Y or Z on Gibraltar, or whatever it may happen to be. And I think that is a very serious problem. The reason I made the case then about the House is if you take the two houses, the House of Lords has had a very good Select Committee report, which I'm sure you will match and go past in the quality of the report. And I think if you look at the political makeup of the Lords, I don't think it's at all clear-cut that the Lords will agree to a motion to opt out if the opt-ins aren't back there again. There are many Liberals who said to me in the Lords that they will not vote with the government on this question. As far as the Commons is concerned, I think there's even a question as to whether the Liberals in the Commons would vote with the government if we didn't succeed in getting the opt-ins back on the process that we've got. I think it's very likely the Labour Party in the Commons would vote against the government unless the opt-ins had actually been secured. And if the opt-ins are secured, which is obviously what the Home Secretary hopes will happen, then I think there's a good chance of it being agreed in both houses. But if the opt-ins aren't secured, or if there's a time factor or a delay, or a renegotiation takes place or whatever that take us past the times that we're talking about, I think there's a real risk to the government in both houses.
You identify, I think, one set of risks there. Just slightly on the other side, I know I've had some people in the Labour Party, indeed in the Liberal Democrats, have said they'd like us to opt back into sort of more measures, and there's some in particular they think we should opt back into that the government's not proposing. There's also the issue with the European arrest warrant, and we just heard from two, I think, very prominent European lawyers how they would advise us to vote against opting back into the AW as the Home Secretary's changes are insufficient, proposed changes are insufficient in their view. I just wonder, will there be some opposition potentially from people who feel that measures don't go far enough?
Well, I mean, I'm no longer in active politics, so I can't make the judgment, but that's the kind of classic debate that you have. I think we're in a situation where if we'd opted into the whole lot, i.e. hadn't opted out, there would have been very little disbenefit to the UK, and we could have achieved the changes that are needed, for example, in the European arrest warrant by negotiation, as I've said in that process. I don't think the argument at the end of the day is going to be, should we have more in or not than the 35? That may be an argument, but I mean, you're closer to the government than I am, but I'd be very surprised if the government was going to go beyond the 35 in this position. And I think that will be the political choice which it'll gel around as we get nearer to those decisions.
But to summarise, you don't believe that the Prime Minister can rely on Ed Miliband to necessarily helping vote these.
Well, I certainly don't see why he should, in any case. But I would certainly argue the Labour Party should vote against. I think they should have voted against opting out. I think it would have been better to do that, and I think there's every chance that will go forward. Now, we'll see what happens, and other colleagues here are closer to Ed Miliband than I am. But certainly the assumption that there will not be a problem about the voting when it finally comes around needs a good deal of close examination.
And just finally, Mr. Clark, the structure of the opt-out, I just wonder, can you shed any light on why the Labour government at the time didn't seek a Danish-style arrangement for these measures and instead went for this sort of either-or block opt-out? Was it intended that opt-out would never be exercised?
I'm certain it was intended the opt-out wouldn't be exercised. Whether that was the reason for the form was chosen, I think it probably is the reason actually, but I couldn't say it that authoritatively because, as I said to the Chairman at the beginning, I wasn't there right at that point when those issues were being decided. But I'm absolutely certain there is no view anywhere in the Labour government that we should be opting out further down the line.
Yeah, I think you speak with significant authority, having only left the Home Office barely a year before that happened. Thank you.
Mr. Clark, your evidence has been extremely helpful, and we will consider what you've had to say.
Thank you for inviting me.
Just one final point. How do we remove from existing EU law and agreements that we've made with our partners those measures that can be regarded as being obsolete? Because, of course, a number of colleagues, including the Shadow Home Secretary, in responding to the Home Secretary, when looking at the list, which is what we're concerned with today, she said some of these measures are obsolete, but they're still there. How do we get rid of those measures that no longer apply?
Well, firstly, she's completely right. Secondly, we have that problem in UK law. That's why we have all the codification processes that go on the whole time by, I may have the title of the body right, is it the Law Commission as a body that looks at codifying our law? We have redundant law as well. But thirdly, the way to do it is to have a serious discussion with the Commissioner concerned and the Commission about making the changes. Now, I have had that conversation with the Commissioner, and I believe that were there a serious discussion from a number of countries, and in this case there would be a number of countries, both on the particular of the European arrest warrant and on the general point that you make precisely accurately, that a number of the measures are entirely redundant at the moment, that they would come forward with a proposal to do that, and that would be the intelligent way to proceed, in my opinion.
Mr. Clark, we're most grateful.
Thank you very much.
Thank you. Order. Could we call Dominic Rabb, the Member of Parliament for Esher and Walton, to the dais? Mr. Rabb, thank you very much for coming to give evidence to this committee. We've heard a number of conflicting voices about the list, we call it the Home Secretary's list of measures that she has decided to opt out of and opt back into. Having looked at the list, are you happy with the list that has been given to Parliament?
Well, I think the 35 certainly cover areas of crime and policing cooperation where we want operational cooperation. Things like the exchange of criminal records. I think the one about taking into account prior convictions in new prosecutions, JIT, the Joint Investigation Teams, all of these are, to my mind, sensible areas of European cooperation. But I think really the question underlying, if you like, rather than purely formulation of lists, the question underlying this decision is whether we should submit to the Commission and the ECJ's control as the price of that cooperation. And so aside from the mere drawing up of lists, what I've argued from the outset is that the government and the UK should use this moment, use the Lisbon opt-out, to recast our underlying relationship where we strip away that supranational control, but we stay operationally engaged. We could use the Frontex model. We could use MOUs or binding bilateral arrangements. The EU has legal capacity. We could do this with them so that we weren't engaged in multiple bilateral negotiations. And I think the point I would also make is the development of a bespoke relationship with Europol and Eurojust is going to happen. Because if you look at their creeping assumption of supranational powers that are already happening, and then you look at the two new regulations in the pipeline and the prospects of us opting into those, and I would put them at 50-50 at best, I suspect we're going to end up having a bespoke relationship with them anyway, where we want to engage and cooperate on a practical level, but we don't want that overarching supranational control. In which case, why not have a sensible conversation now? What better juncture than now to have that wider strategic conversation?
So I'm not really clear. Do you think that we should accept what she has said? Do you think in writing our conclusions, and you come here because you're an expert, you're not just a member of the House like the rest of us, you clearly know this subject extremely well. I understand your second point about the European Court, and we'll be exploring that later. Mr. Clapperson will explore it with you. do you think that we should accept this list and vote it through the House?
But how can you divorce those two questions? That's my problem with this.
Right.
I mean, I think those 35 areas are good practical areas, but how can you divorce whether we cooperate with joint investigation teams from whether there's ECJ and European Commission control over that?
Yes. Do you accept the argument that's been put forward by some that, as far as the other items are concerned, I think 100 other items, some of those are obsolete, and therefore there's really no point in opting into those? I accept your point about the European Court, but just looking at it as an intellectual discussion.
No, we shouldn't have bad law on the statute book, whether it's British or European.
So you're happy for them to go? The others that you looked at? Yeah.
No, the question is whether there are too many, not too...
Of course.
Too few.
I understand that.
Plus the wider underlying points.
We'll come on to the European arrest warrant slightly later. James Clapperson on the European Court.
Do you regard as being significant that whereas under the previous arrangements for these measures which we were party to under the previous Justice and Home Affairs chapter, under the new arrangements, under the new law, under the Treaty of Lisbon, we will be subject to the European Court of Justice?
Do I regard it as significant?
Yes.
Yeah, I think it's very significant for all of the measures. Whether it's the ECJ or the Commission, they're integrationist bodies at the EU level, so they're going to look to expand their powers over time. And if you look at the ECJ in particular, the Metop case in 2008 on asylum, the Pepino case in 2005 on criminal procedure, they're good examples. And I mean, I'm out of touch with all the latest case law, but there's some excellent evidence from Martin Howe QC to the House of Lords Committee, and I basically agree with all of that, which warns about the judicial legislation from the Luxembourg Court. Thank you.
Thank you. Mark Reckless.
What do you think would be the practical impact of opting out of the European arrest warrant on day-to-day cooperation?
The practical effect? Well, I think there'd be the benefit. On the benefit side, you'd have less of the miscarriages of justice, and I believe you've already interviewed some of the victims. And I have a constituent myself, Colin Dines, who's just going through this process, almost certainly likely to be have the warrant dropped, but I should say not before he's suffered a stroke under the pressure, and I can vouch that this man, as well as I could for any man or woman, is innocent. Retired judge, impeccable standing, really put through the mill. So I think we'll see less of those kind of miscarriages of justice. On the downside, I think there's been a lot of scaremongering. The worst case scenario is that we'd get a bit more delay in securing fugitives back, but that would seem to me to be months, not years. And I think there wouldn't be a case. I don't think you'd have a single dangerous criminal who would go free because we could, of course, apply the underlying Council of Europe conventions. And I think what's interesting in the government's command paper is it recognises this, that we're talking about delay, not bad people going free. So I'm just trying to give you the pros and the cons. I do think there are pros and cons. I mean, but the Council of Europe conventions, if we did opt out of the European arrest warrant, would I think be the starting point. You'd presumably try and negotiate some enhanced procedures somewhere between that and the AW.
The Metropolitan Police drew our attention to, I think, over a quarter of people that at least they were arresting in London were now foreign nationals, and over half of those were EU citizens, and they stated it seems to see that it followed from that we must have the European arrest warrant in order to expedite extradition. Could deportation have a use in that scenario rather than going through extradition, expedited or otherwise?
I think it's a very good point. Let's face it, what we really care about when we talk about miscarriages of justice is our own citizens. Don't get me wrong, I don't want to see rough justice for anyone, but I think we as a government and as a parliament have a particular responsibility to make sure we're not extraditing our own nationals. And of course, deportation and the ability to deport foreign nationals back to other European countries and of course non-EU countries have been increasingly made more difficult because of fetters under various dimensions, human rights law of course, but particularly under the EU Citizenship Directive, which came into into force at exactly the same time as the European arrest warrant, and has been narrowed the grounds for deportation, again because of the interpretations of the Luxembourg Court. So if you compare the data, for example, Jamaica, Australia, America, we rely increasingly on extradition and the EAW because our scope to rely on deportation of foreign nationals has been so whittled away. And I think that's a strategic legal mistake.
Mm-hmm. And so finally, from me, do you see any scope for deeper cooperation with some countries, both within and outside the EU, on these type of issues, if we could restore confidence in the system, that people wouldn't be treated unjustly, as we saw from two people subject to a European arrest warrant from Greece and Portugal in terrible circumstances before this committee yesterday?
Do you mean should we cherry pick the countries that we have enhanced cooperation with? Is that your question?
I mean, is there a danger that a lack of confidence in, for instance, the Greek and Portuguese systems may seep into a wider concern about extradition and judicial cooperation more generally?
I think it's already happened. The most astonishing omission from the Baker review into the independent review into extradition was the evidence from our most senior extradition judge, Lord Justice Thomas. And he says that it's already become unworkable and that Northern European countries feel a deep lack of faith in it. This is Britain's most senior extradition judge, and he said that the system has become unworkable. And it's precisely because we have this assumption of common standards, and yet it's clearly not the case, whether it's lousy jails in Greece or a defunct or slow or incompetent judicial system in Italy or Spain or wherever it may be, or Portugal.
So would an exercise of the opt-out by not going back into these measures, could that actually lead to a system where there was better practical cooperation, at least with those countries which have high standards in these matters?
I think you'd always have the option then to, on a bilateral basis, to work out who on a selective basis, who do meet the standards that we expect for our nationals. And equally, not just on the extradition side, we'd, depending on the wider renegotiation of Britain's JHA relationship, you'd look at the deportation side of things too.
Thank you.
Thank you very much. Lorraine Fulbrook.
Thank you, Chairman. Can I ask, based on everything you've said, that do you believe that the planned legislative changes proposed by the Home Office will actually improve the operation of the European arrest warrant as conducted in the UK?
I think they would help mitigate the bluntness of the European arrest warrant. And there are two aspects which I've looked at particularly. One is the proportionality bar, and the second is the bar for cases which are not trial ready. That's my own experience with Colin Dines, and I think some of the witnesses that you've had before you already. Yeah. On the detail of it, I've sought legal advice on how robust they would be, because they're quite detailed amendments, and I'm going to wait until I've received that to take a firm view on their adequacy. But I think there are, even if we're confident they'll do what it says on the tin, there's still two problems. One, I think, is the problem of a lack of an evidential threshold, and whether or not between the EAW box-ticking exercise and the prima facie test that we used to have, whether there's somewhere a compromise in between. And secondly, then, the question of ECJ jurisdiction over extradition of our nationals. And the latter is quite a serious point. We've set up a Supreme Court in this country, and yet we continually subordinate it, whether it's to Strasbourg or to Luxembourg. And this is on decisions relating to the freedom of British nationals. I think it goes to the heart of the British justice system.
Okay, thank you.
Julian Huppert, Dr. Julian Huppert.
Can I turn to Eurojust and your take on the benefits to the UK of involvement with Eurojust and the things surrounding it? I mean, I think you describe it as a Category 1 measure which the UK benefits from. Can you say a bit more about that?
Well, I worked in The Hague for 3 years when I was at the Foreign Office, and one of my jobs was liaising with Europol and Eurojust. And I can certainly see operational advantages in a college of cooperating national prosecutors, whether it's sharing information, telling who's the right person to pick up the phone when you need to expedite a case or find out more about it, general coordination of work, the kind of practical cooperation we've talked about. I think on the downside, that Eurojust is already acquiring supranational powers to demand information from UK prosecutors, and the new Eurojust regulation will strengthen those powers. They'll also force the UK to cooperate with the new European prosecutor and give the Commission power over the direction of Eurojust. Just a second, on the new board, the executive board, there is going to be a seat for the Commission. So again, you've got this creeping supranational power by stealth. This is all new, it comes in the new regulation. And I think the question is, at what point does Eurojust go through these stepping stones from being a really sensible college of cooperating authorities, which I saw and I'm a fan of, to something more along the lines of that half step to the European Public Prosecutor?
I mean, obviously, future changes will be things that Britain can be involved in or not. When it comes to things like joint investigation teams, I think you say UK benefits from joint investigation teams. Is that still correct?
Yeah, I think we benefited from it, but when we opt back in, the question is whether we want the nature of that cooperation to be subject to Commission jurisdiction and ECJ jurisdiction. There's a carve-out for ECJ jurisdiction over JITs at the moment. So, for example, I wouldn't want to see the European Court of Justice having the last word on the balance of operational powers that we give to foreign officers on British soil. But again, once you give jurisdiction to the ECJ, it will whittle down, or the risk is that it will whittle down that safeguard. And I think that's something to look at. But you're right, it's an area where we should be in favour of practical operational cooperation, but not political control. That's the distinction I've drawn.
And when it comes to cross-border criminal records checks, I think the House of Lords report that you're supportive of those continuing. And I mean, do you share a concern that if we weren't to go ahead with all of these, either you'd have to set up some other multilateral thing, which would be hard to negotiate with everyone else, or you'd require a vast number of bilateral agreements?
No, I think I tried to make the point earlier, but let me, first of all, there is already a model for operational cooperation without the political control, and it's Frontex. And if you ask the executive director of Frontex, is Britain a good partner? She has said very clearly it makes very little difference that we're not formally signed up to it as a sort of formal member. There's no difference between our operational cooperation. So that's a good model. It's already happening. Why not expand that? I think because the EU has legal capacity in this area, we could avoid negotiating with 26, 27 other countries, although actually we might want to do that in certain areas for the reasons that Mr. Reckless has highlighted. So look, what this really requires is a bit of elbow grease. All these people putting insurmountable obstacles into forging this kind of bespoke relationship are ignoring the fact that our non-EU cooperation with the US, New Zealand, Canada, Australia is brilliant, equally as good as most of our European cooperation. That all relies on those mechanisms and those procedures.
I hadn't realised you were such a fan of the US-UK extradition treaty, but I expect you went with some reservations.
No, I've made it very clear. I'm not such a fan of the UK-US extradition treaty. I've made the case for reform in that area as well.
Indeed, yes.
But unlike you guys, I wouldn't duck the issue, whether it's dogmatically with the EU or dogmatically with the US. I would look at the nature of the cooperation underlying it, and I'd be in favour of good law enforcement cooperation. But I wouldn't just throw aside interests of British citizens or the wider political control that we've got a duty to our constituents to retain and exercise.
I think all of us are trying to argue for the interests of our constituents and how to make sure that they are safe and secure and free. Thank you, Chair.
Just for the record, we actually take a very sceptical view of the extradition treaty. As you know, you've given evidence to us before, and we do think it needs to be changed. But you mentioned Frontex. When the committee was in Greece a few years ago looking at the Greek-Turkish border, which is the border that allows so many illegal migrants to come into the EU, we were specifically told, as far as Frontex was concerned, that because we were not part of Frontex, we could not be part of the rabbit forces that seek to police that area. You're quite confident that we can still be a part of organisations, not be formally joined to them, but still cooperate?
Don't take my word for it. I'm quoting the executive director of Frontex, and I cite her in my pamphlet, which I will shamelessly plug, but only for the purposes of I can give you this copy, only for the purposes of giving a short answer. There's a section here on Frontex, and the fact is that by staying out of it, according to the head, the leader of that organisation, actually our operational cooperation is as good, if not better, than many formal members.
Indeed. Michael Ellis.
Thank you, Mr. Chairman. Well, Mr. Raab, first of all, can I congratulate you on the level of expertise you have reached in this area? Can I just ask you about the opt-in decision in itself? Because what do you think would be the best arrangements for the House to actually undertake to approve the opt-in measures? Should it consider each separately, which would clearly be a very long, tortuous process, considering how many there are and each division takes approximately 15 minutes, or should it consider all of them together? Or in blocks, or something in between?
I have to say I'm not wedded to any particular answer to this. I think there are pros and cons. You'd get perhaps more, proper substantive scrutiny measure by measure, but as you say, it'd be quite a cumbersome approach. I think on balance, I would say vote on the package, mainly because it would allow us to deal with the underlying questions of jurisdictional and commission control, which I mentioned. And I think we've got to view this as a package. So that would, but I'm not particularly. I don't have strong views on it.
You're relaxed about that.
I'm relaxed about it.
Thank you.
You don't think that there is a case for taking out the measure concerning the European arrest warrant, because that's the one that's caused most concern. I understand your principle about the European Court, but in terms of the practicalities, witnesses even today have told us their real concern about the way in which the European arrest warrant operates. You don't think that there is a case for just taking that out and taking the rest as a package?
You mean if I don't get my broader strategic approach that we...
Exactly.
Yeah, I think there is a case for that, yes. I mean, I've tried to preserve my position to a degree because I want to be fair and look properly at the substance and take legal advice on the safeguards. But I think probably, in any event, it will leave a lingering doubt and a question relating to the evidential threshold and, as I said, ECJ control. So I think there probably is a case for that.
And I assume you're against the idea of a European prosecutor?
Absolutely.
Is there anything European you're not against?
Yeah, I mean, I'm glad you asked that because, I started my life as a competition lawyer in Brussels, my professional life, and I think competition law is a very good area, good example of an area where actually you want to have cross-border supranational control. There's lots of question marks about the supranational competition authorities, but that's an area where you do want it. Crime and policing, law enforcement, I suspect it's the least worthy candidate for that creeping supranational control. But not for ideological reasons.
Good job I asked the question.
So just to clarify things, on the European arrest warrant, you've looked at the Home Secretary's 4 principles, things she wants to change, and you're not satisfied that the proportionality test that has operated in Germany is going to meet the objections that people have?
No, what I said was I wanted to look and take legal advice on the adequacy of them before I came to a firm judgment on the European arrest warrant side of things. I have to say, the proportionality one's not the one I worry about. The big problem with the European arrest warrant, contrary to the way it's being conveyed and portrayed, is not the piffling cases. It's the serious cases. My constituent, Colin Dines, is accused of fraud. That's a serious case. Andrew Sameo was accused of murder or something serious. I think in all of the cases, Deborah Dark, Edmund Arapi, the others that you've had before you, these were serious cases. So the proportionality bar isn't the one that I'm looking at most, it's the trial-ready bar. Even then, even if those were adequate, even if they came back and they were very robust, I think there's a question about whether we need an evidential threshold, and even then, who do you want having the last word in it? So I want to wait and look at it properly. I want to be fair to the government, but I do have serious reservations about the EAW.
Mr. Rabb, on behalf of the committee, thank you very much for coming here, and I'd be grateful if you leave your pamphlet on the way out so we can properly examine it. Thank you. Thank you very much indeed. Order. Could we now call the Director of Public Prosecutions, Keir Starmer? Mr. Starmer, welcome back. This is your valedictory appearance before the Home Affairs Select Committee. I'm afraid we didn't sign a card for you or bring any balloons, but it's 5 years since you took on this job. To me, you look exactly the same as the first time you appeared before us. So before we finish, we're going to ask you about a number of things concerning the way in which the CPS is going to develop, or you'd like to see develop. But I'd like to start with a couple of issues that are in the public domain at the moment, and specifically concern you. You and your organisation, not you personally, but the organisation has had severe criticism this morning from barristers acting for Michael Lavelle that the case against him should never have been brought because of a lack of evidence, a lack of detail, and the damage to reputation that has been caused by the prosecution, which, according to Alistair Williamson, he said, was prosecuted without a single bit of corroborating evidence. Would you like to respond to this very serious criticism?
Yes. A proper assessment of the evidence was taken in the case. The decision to proceed was the right decision. There is a safeguard within our system, and that is at the end of the prosecution case in court, it is not only open to the judge, it's the duty of the judge to stop the case if there's no case to answer. That did not happen in this case, and therefore there was a case to answer. That case was answered, and the jury took some time to consider their verdict. So it's a perfectly properly brought case. It's not a case on which there was no evidence. Had it been, it would have been stopped halfway after testing of the evidence. Mm-hmm. It is true that the test of a prosecutor is a realistic prospect of conviction, and the test for the jury is whether the case is proven beyond reasonable doubt, having heard all the witnesses. But the fact that a decision is taken to start a case and doesn't end up in a conviction does not mean that it was improperly brought. Mm. And I think it's very important that we reaffirm that. The idea that if a case results in an acquittal, it shouldn't have been brought is wrong.
So you're not going to review any of the issues around it, as has been said in the press today?
Because the case proceeded beyond the prosecution case, any decision not to report it would be to say, although there's a case to answer here, we are not going to prosecute. I don't seriously think anybody's suggesting that's a position we should adopt.
Yes, I know colleagues would like to come in on this. Eleanor Laws, your QC prosecuting, said to the jury, you may think this is about some kind of celebrity witch hunt. That was a very odd thing for her to say, wasn't it?
Well, I'm not going to comment on her closing speech. That's a matter for her in the trial that she's conducting. I can be absolutely clear. The test for bringing a prosecution is the code test for Crown prosecutors. The question is whether there's sufficient evidence and whether it's in the public interest to prosecute. I'm satisfied that test was properly applied in that case, and I expect it to be properly applied in any case, whoever the suspect is.
And finally on this, from me, do you think that sexual abuse suspects should be granted anonymity like their victims, as has been called for as a result of this case? The issue being the huge publicity for people in celebrities, those who are known, obviously in the press, they feel their reputation has been damaged even after they've been acquitted. And the defendant in this particular case, or the former defendant, said anonymity should be granted. Are you proposing to look at that again, or are you quite happy with the situation?
I understand those concerns, but the arguments are well rehearsed. In many cases, the fact that a suspect or a person once charged is named leads other victims to come forward. And we've got a number of examples of cases where, having named somebody once they're charged, other victims have come forward, and that's enabled a case to be built. I do understand the anxiety. I think a judgment call has to be made. My own view is that naming on charge is appropriate, particularly in a country where we have open justice. So you do it all again,
you're very satisfied everything was properly conducted, you would bring the prosecution again?
This was a properly brought prosecution according to the proper test. It would have been wrong not to have taken a case where there was a case to answer, and that's this case.
Thank you. We have some quick questions from colleagues. Mark Rectors. Yes.
So Mr. Starmer, you seem to be putting through, at least to me, what seemed to be quite a novel proposition then, which you say that if the defence failed to put forward there's no case to answer, the judge doesn't determine there's no case to answer at the halfway stage, then it must be the case that the CPS acted properly in bringing that prosecution.
Not that it must be the case, but it is impossible to argue that there's no evidence, or there's no case, because if that was the situation, it would be the duty of the judge to stop the case. So all I'm saying is that really blocks the argument. This was a case where there was no evidence. The case was presented, and and it was open to the judge to say if there's not the right evidence, it won't proceed. That's the only point I'm making. I'm not saying that's the test of everything. Yeah. But
Mr. Starmer, you're making a very different point then, which you said no evidence, whereas you stated before, quite correctly, that the test was sufficient evidence for a realistic prospect of conviction. Well, so whether or not the judge decides there's no evidence, how is that determinative of whether there's sufficient evidence for a realistic prospect of conviction?
Well, the test for the judge is whether there's a case to answer. Now, it's not the same test whether there's a realistic prospect of conviction, but it's not far removed. The judge has the advantage of having heard the prosecution case and seen it tested. My simple proposition is that in a case where the prosecution's evidence has been heard and the judge has not removed the case from the jury, it is self-evident there's a case to answer. Now, if anybody is suggesting that in a case of serious sexual allegations, the Crown prosecution should form the view there's a case to answer, but the proceeding shouldn't be brought, then I think there's a debate to be had. It is an example of our system at work. We bring a case based on a realistic prospect of conviction. We convict on the basis of beyond reasonable doubt after the evidence has been heard.
Too much on this, but Mr. Clapperton and Mr. Ellis, I know, want to come in.
I'm only familiar with this case from newspapers. I'll take great interest in it. Is it the case that it was always the decision of the prosecution to prosecute all the way through, or not?
No, there was an earlier decision that there was insufficient evidence. That was then reviewed.
Now, who took that decision?
The decision on review was taken by Alison Levitt, QC, my principal legal advisor.
Sorry, but who took the initial decision that there wasn't enough evidence?
The team in CPS Northwest. So it was a case that was determined by the CPS Northwest team. When it came to be reviewed, it was reviewed by the principal legal advisor, Alison Levitt, QC. She reviewed it and came to the view that there was a realistic prospect of conviction. In those circumstances, the case proceeded.
Was that on the same? Was the evidence that she saw the same evidence that was seen by the initial reviewer, or the initial decision taker, or was there more evidence?
It was the same evidence plus some new evidence.
And was the new evidence from the same source as the old evidence?
I would rather check that if I'm going to be asked detailed questions about
the evidence would have been presented to the court anyway.
It was presented to the court, yes.
And Mr. Ellis has a quick point on this.
Yes, thank you. Mr. Starmer, do you think there is a general pressure to prosecute people who are in the public eye that falls onto the CPS because those cases attract media attention? And not proceeding makes it look, in the eyes of some, that the CPS would just be looking to protect famous people. In other words, do you think there's a natural human pressure that is added to by those making these decisions, if they're people in the public eye, that on this one we ought to prosecute and let the judge decide to throw it out at half-time if he doesn't think there's enough evidence, or let the jury decide to acquit and let the ball rest with them?
No, I don't think there's any pressure, and I think if you look at recent cases, you'll see examples of cases where we've decided to prosecute and cases where we've decided not to prosecute so-called high-profile individuals. I think it does my staff a bit of a disservice to suggest that they're not properly applying the Code for Crown Prosecutors, because they are.
Right. Well, I wouldn't want to imply that that's the case, but it would be outside the realms of possibility that those involved in making decisions like that are under more pressure for a non-routine case than for a routine case. How many cases, do you know off the top of your head, how many cases are thrown out at half-time by judges? How many CPS cases tend to be thrown out at half-time?
Again, off the top of my head, I can't give you a figure. I'll certainly give you a figure.
Would you write to us for that?
I will. I mean,
just an approximate indication.
Just staying with sexual offending, what is clear is that the conviction rate for sexual offending, in particular rape, has gone up year on year for the last 2 years, and more people are now pleading guilty than have ever pleaded guilty before. That signifies to me that we're making the right decisions and building strong cases. But I'm very happy to provide any further statistics that the committee
If you could write to us, that would be very helpful.
Whichever
yes, I
offences
think
you
the
want
remarks certainly don't necessarily apply just to one type of offending or allegations. I mean, this is a general point.
Thank you, Mr. Ellis. David Winnick.
Mr. Starmer, are you aware that there is a feeling among some politicians, at least, that they should be very wary indeed of interfering in any way with the judicial process, and that the long-established separation between Parliament and the judicial process is a very good one and should continue?
Yes, I am, and I would agree with that.
Thank you.
Good. Let us move on to the European arrest warrant. We'll deal with other matters colleagues want to raise at the end. Has the government got this right? You've seen the measures, 135, opting out of 100, opting in of 35. You gave evidence to the Lords Committee. You said that if we were to opt out and not opt back in, this would lead to uncertainty, uncertain, cumbersome and fragmented approach to cross-border prosecutions. Are you happy now?
Broadly, yes. I mean, my concern, and it was a real concern, was about, broadly speaking, Eurojust, joint investigation teams, mutual recognition of EU convictions, European arrest warrants, and some of the provisions around asset freezing and confiscation. They were my main concerns, and broadly speaking, all of the important provisions there have been opted back into. So, assuming that is successfully negotiated, the concern I had last time I gave evidence on this issue it has been lowered.
So those that they've left out, that the Home Secretary has left out, there's no more other measures that you think, since we're going to debate this and discuss this now, we might as well opt back in at this stage?
Yeah, I mean, I'm speaking only from a prosecutorial point of view.
Yes,
I know APPO gave evidence where I think they identified 4, mainly relating to Europol, that they were concerned about. From a prosecutorial point of view, our view is that the remaining measures are not key to prosecutors and or in any event will be overtaken by incoming post-Lisbon provisions. So I wouldn't want to put before the committee a particular provision which I think should be added to the list from a prosecutorial point of view.
Yes, and you also mentioned, when you were asked about this, that the CPS and you as DPP had not been consulted formally about this list before it was agreed by the government. Were you subsequently consulted?
We were able to contribute our views to the Home Office and to the MOJ, and I had a private meeting with the Home Secretary and Justice Secretary to set out my concerns. So I certainly feel that, as I sit here now, I've had the opportunity to make my concerns
And the concerns
clear.
have been met?
And the concerns that I set have been met, assuming that we successfully negotiate through and do opt back into the measures in question.
Yes, thank you. Michael, sorry, there is one question. A witness gave evidence to us yesterday, Professor Peers. Obviously you haven't seen the transcript, and I'm sure you don't spend your time glued to the internet to see what the Home Affairs Select Committee is doing.
I do look at some of your proceedings. I do, and particularly in preparing for this, but I have to confess that yesterday was a rather busy day for one or two reasons, and I missed it.
But what Professor Peers said, I have to admit, I wasn't here for it because the Prime Minister was appearing for the Liaison Committee, so this is a transcript that I've read. Professor Peers, who's a noted expert on these subjects, who gave evidence to us yesterday, said that there is going to be a weekend where Britain will opt out and then opt back in again. He's very worried about this weekend because he feels that the European arrest warrants that have been issued will then fall, and people we're expecting to return to the UK will not return, and they'll all have to be reissued again. Do you know about this missing weekend?
I don't, but I would be concerned if there was any real gap between the existing provisions and opting back into the 35. I think, we'll have to, or my successor will have to think very carefully about what we put in place to make sure that there are no unintended
because that
problems.
would have been the perfect thing to consult you on, rather than a private meeting where you've express concerns to ministers, surely a proper roundtable meeting with all concerned, because nobody seems to be giving us this answer. When the opt-out is done, before the opt-in comes back, what's the law?
Yeah.
Nobody knows.
No, and I haven't been party to any discussions about that, but I would be concerned, obviously, if there is a gap that leads to any difficulties.
More work will need to be done on that for sure.
Yes,
Michael
I agree.
Ellis.
Thank you. Well, I'd like to ask you about the soccer list, actually, on the issue, before we come to the opt-ins and opt-outs.
Mr. Ellis, could we do that in the end? And could we just do...
I'm quite happy to leave that till the end.
Thank you.
As far as the involvement, what I want to then ask you about as far as the opt-ins are concerned, is the what involvement that the CPS have had in drawing up the opt-in list. Have you had any...
well, I mean, as I say, we
input?
I was asked by the Home Secretary and the Justice Secretary to set out my view and any concerns I had, and I did that.
Yeah.
And more generally, our team has been feeding in our observations to the Home Office and the MOJ. So in that way...
So you're happy that there's been adequate liaison between you and government as far as, and your offices are concerned, as far as an opportunity to inform the government's decision-making in this regard?
I feel I've been given a proper opportunity to make my concerns known, and whether because of that or despite that, the 35 provisions that we're opting back into cover most of the concerns that I had.
Thank you very much.
Thank you. We'll come to the other matters later. Dr. Julian Hubbard.
Thank you, Chair. You just said the 35 measures cover most of the concerns you had. Can you be quite clear, firstly, about which ones you would like to see added?
Well, I'm not putting before the committee any measures that I specifically would want added. Okay. From a prosecutorial point of view, they're either not key in the sense that we can continue to work efficiently with our partners in any event, or incoming post-Lisbon measures will cover the same territory. My main, as I said, my real concern was Eurojust, JITs, EU convictions, EAWs, and the provisions about assets, and they were very real concerns, but as things stand, they're on the opt-in list.
But you'd be alarmed if any of them fell off, presumably?
Yes, I would. The concern I expressed last time would then obviously return.
And can you just say a bit more, we've had a lot of discussion about the European arrest warrant, but can you say a bit more about Eurojust and the joint investigation teams, and give us a flavour of the consequence if we didn't have them, and indeed the successes that we've had as a result of them?
Yeah, we use Eurojust quite heavily. They have a number of benefits from a prosecutorial point of view. First and foremost, we get access to all the other desks, the 26 other desks. There's a hub with facilities, language skills, legal expertise, etc., to do effective cross-border work. We can have multi-jurisdictional meetings, so if there's an investigation going on in more than one country, a decision has to be made as to where it's pursued. We can coordinate arrests and searches, and if that's not coordinated, it doesn't work very well. And it's a neutral ground for resolution of issues. So Eurojust is of great benefit to us as prosecutors, and we've been concerned if it went. Allied to that, of course, just if I could say, on JITs, firstly, there's some very good examples of JITs doing very good work, particularly in drugs and trafficking kind of cases. But one of the great benefits is that if a JIT carries out an investigation, the evidence is more easily admissible in this jurisdiction than if there's no JIT and we have to go through the other arrangements for getting evidence from one jurisdiction to another. So there are a number of very real benefits, and we use Eurojust on a daily basis.
Mr. Raab suggested that one could resolve these things by having a sort of looser voluntary cooperation type scheme. I think you heard his evidence. Yeah. I don't want to misquote him, not having any transcript yet. Do you think that's a realistic prospect?
No, I don't. I think Eurojust works very well, and the cooperation increases every year, and I don't see any advantage in withdrawing from Eurojust to set up other arrangements. I think it is a very effective way of proceeding.
And you think it would be fair to say that if we were to withdraw from Eurojust and related measures, that would make it harder for you to prosecute people who have committed serious crimes in the UK or elsewhere?
Yes, we regularly work with Eurojust and JITS on cross-border crimes in Europe.
Thank you.
Thank you. Lorraine Fulbrook.
Sorry,
my apologies, but David
European arrest warrant, we've had conflicting evidence, as to be expected, obviously, those for, those against, perhaps to some extent those who stand in the middle. Do you think yourself that what the government is proposing to do will undermine the fight against criminality in Europe?
Can I just be clear? Do you mean the steps that the Home Secretary is taking on proportionality, pre-trial detention and dual criminality? My starting point on this is that they are problems that need to be addressed. I would agree with that. But they're not problems caused by the EAW. If you take proportionality, it wasn't the EAU framework that introduced that problem. It was there before. If you go back to the older arrangements, there were no proportionality issues, no provisions there. So the problem of proportionality needs to be addressed, and I'm supportive of what the Home Secretary is trying to do. But it is wrong to assume that that's a problem caused by the EAW. That's a problem that pre-existed the EAW and will be there if we opt out of the EAW and go back to the old arrangements. We'll have precisely the same problem. So I'm supportive, of course, of the work that's being done here.
Were you consulted on this particular aspect?
We have been consulted on these provisions, and I've seen the drafts of various ways of dealing with it.
You've seen the drafts. I'm just trying to see if that could be considered consultation. I mean, were you consulted in the sense before there were drafts or anything? Your general view, in view of your position?
The issue came up in my conversations with the Home Secretary and the Justice Secretary, but our team has been feeding in on this for some time. We ourselves were part of a team that went to Poland in 2008 and 2010 to talk to our counterparts to see whether there wasn't something we could do about what appeared to be disproportionate, a number of disproportionate cases where Poland was seeking the extradition of people back to Poland. So this has been something that we've been working on for some time because, quite apart from anything else, the resources that are needed to put into the large number of cases which fall into that category are sometimes quite considerable. So it's a problem that's been on the table for a long time. I support any steps that deal with it, but it in fact is not an EAW problem.
The argument was put by colleagues to Charles Clarke, and which I think you heard, namely that there could be individual treaties, extradition treaties, that there's really no necessity for the European arrest warrant, it's too cumbersome, has caused too much injustice and the rest of it. What's your response to that, Mr. Starmer?
I'm really concerned about that. Firstly, there's an unresolved legal issue as to whether you could resurrect the old arrangements or strike new arrangements, or whether those still within the provisions would be bound to seek some different kind of arrangements with the UK. And that needs to be resolved. Assuming for a moment that it might be possible to fall back on the old arrangements, we need to remind ourselves of the problems of those arrangements. First and foremost, it took much longer to resolve extradition proceedings. These days, on our figures, we usually get somebody back to this country within about 1 to 3 months of our request in very serious cases. That took years in the past. Secondly, a number of countries under the old arrangements would not extradite their own nationals. 9 countries, I think, would not extradite their own nationals, which meant if we were wanting a national of another country back, we couldn't get it. And we then had to take the sometimes difficult decision as to whether we would export our evidence to the other country to see whether it was possible to prosecute in those countries. That was not very satisfactory. And so I do have real concerns about falling back on the old arrangements, even if that is permissible. I think that would and those delays and those difficulties were there at a time when the number of extraditions was far fewer. It will creak if we go back to that with the sorts of numbers we're talking about now.
Recognising some of the injustice, which people have suffered. We had 2 witnesses yesterday. Overall, would you say, therefore, that the European arrest warrant has served a positive purpose in dealing with criminality and overcoming some of the previous problems?
Yes, I would.
Thank you.
But it's in need of reform.
I'm supportive of the proportionality reform. Anything that can be done on pre-trial detention, I understand that concern. I think, again, the Home Secretary has got some proposals there. I'd be supportive of that. And possibly some work on dual criminality, although that's slightly more complicated. But I would agree that they are problems that need to be dealt with if possible, because not by withdrawing from the EAU.
You told the committee you went to Poland. Poland was one of those countries where judges apply for the European arrest warrant on very what we would regard as minor offences. And we've had evidence today from a Polish-British barrister who says they will just issue these warrants and there's nothing we can do about it.
Yes.
The reforms don't stop that happening, do they?
No, I mean, I think there are a number of possible reasons for that. In the guidance I've given to my prosecutors is to exercise discretion on whether or not they're going to apply for a European warrant. So we've built in a filter before we do it. It is different in Poland because the prosecutor doesn't have the discretion that we have here. It's a different legal system.
Yes.
And the judge is seized of the investigation at a much earlier stage. And therefore, in many respects, the individual is asked to go back to court at a stage that we would consider still to be the investigative stage, but the system is different. So
yes.
That's what we were discussing with our colleagues in Poland.
Sure.
I don't think it's just a question of them not scrutinising the same way. It is a different legal system.
It is a fundamental issue, yes. James Clapperson and then Lorraine Fulbrook.
Director, I mean, we've heard what you've got to say about this. Somebody listening to your evidence today would be tempted to think that you've almost gone as far as to say, would it be impossible to do extradition without the European Union?
I wouldn't say it'd be impossible, but what I said was we need to remind ourselves of how the arrangements worked pre the EAW. It took a long time to get people back to this country, and some countries didn't extradite non-nationals. Now, if there's a serious offence committed in this country and somebody goes to another country, then I think the citizens of this country would be pretty concerned if we couldn't get them back. The best example.
I appreciate
but the best example is the 21/7 bombing case, where we got Hussein back in 56 days from Italy. If we were still waiting to get him back and embroiled in negotiations and legal argument in Italy, people would be saying to us, what on earth is going wrong? But we got him back in 56 days and tried him and convicted him.
I mean, you heard it was conceded by Dominic Raab in the evidence he gave to the committee that it might take a bit longer, but it could still happen.
I'm not saying it's impossible.
I mean, we've managed to have extradition arrangements with, I don't know, pick a country at random, Australia and Canada. How long does it take to get somebody back from Australia who's committed an offence?
It takes longer than under the EAW. I'm not saying it's impossible, but I'm saying it's a choice. Do you want people back speedily for serious offences like the 21/7 bombing, or do you want it to be a longer process? Do you want to extradite back to this country nationals of other countries who have committed or are alleged to have committed serious offences, or do you want your prosecutor here to have to pass the file to that country to see whether they can't bring a prosecution? For my part, I know what answers I'd give to that, and I think I'd go so far as to say I think most people would say if there's a serious allegation against an individual, would rather have them back to be tried for a serious offence speedily, and whether or not they happen to be a national of another country.
Thank you, Chairman. I'd just like to pick up the reforms of the European arrest warrant that the Chairman mentioned. Do you think the planned legislative changes proposed by the Home Office will actually improve the operation of the European arrest warrant in the UK?
I think it's a little bit difficult to predict, but I hope so, and I can see that if there's some flexibility at an early stage for law enforcers as to what might be called trivial or disproportionate case, and if the court finally can look at it, I can see that that may help. I mean, it's a problem that's got to be dealt with, and I'm supportive of those provisions. Time will tell whether they make the necessary difference. I hope they will, but if not, we'll have to go back and try again in some other way. It may be that in the long run, the better alternative is a pan-European change, but that inevitably is much more difficult and likely to be to take much longer.
On the issue of proportionality, in consideration of arrest warrants, do you think the planned changes will address that?
Well, I hope so. I mean, on the face of it, the proposal is to give the court power not to order extradition if it will be disproportionate. So that blocks that case. In my own view is there ought to be a discretion in addition to that slightly further up the line. I mean, in other words, if as a prosecutor you can predict that this is a case that the court is going to rule as disproportionate, then it would make sense for the prosecutor here to have some discretion to say, well, we're not going to waste time and money getting it to the court, for the court to do the obvious thing, and that is to knock it out. But I mean, I think that's a question of discussion and negotiation as we proceed with these measures. Yeah. I mean, our collective task is to try and make them work.
Thank you. Oh, sorry, my apologies.
Could I just follow up about the Polish arrest warrants, which is something which has vexed this committee somewhat as to the amount issued by Poland. Is there anything you can update the committee on the work that the Crown Prosecution Service has been doing with the Home Office regarding the number of European arrest warrants issued by Poland?
I'm not sure I can go beyond saying that we're involved in the discussions as to what the answers are. But I'm very happy, if there is anything more to that, to write to the committee and let you know.
Okay, thank you.
You took some umbrage earlier when Mr. Ellis suggested Crown prosecutors might not always apply the code properly. Did your team in the North West apply the code properly initially in the Lavelle case?
Yes.
Well, how come it was then overturned following a review?
Because when you review a case, it is inevitable that you take a fresh look. There was some further evidence, and the view taken on the re-look was that there was a realistic prospect of conviction. And we've just introduced, quite rightly, a victim's right to review. This is a right of victims to ask the Crown Prosecution Service to look again at a decision. We can't run that regime on the assumption that if on an honest and open review a different decision is taken, it necessarily means the first decision was wrong.
So with a victim right to review, is there also a celebrity requirement to review?
No. It's a victim.
So why in this case was a decision taken to overturn review and then overturn that decision for Michael Lavelle?
The scheme that is now in place was put in place in June of this year. That is a right of review. That means a victim whose case is not being proceeded with has a right to ask the CPS to review the decision and doesn't have to put a reason on the table or go through any formal procedure. We will then review the decision. We've been doing that for 3 or 4 months now. Before that, which would be this case...
But I was really asking about that point. How many decisions do you get which aren't reviewed when it's just an ordinary member of the public who may not be in the public eye, yet when, in this case, when a decision was taken not to prosecute in the North West, it was reviewed and overturned in a celebrity case?
This arose because a complaint was made, and that complaint procedure's been running for years.
Is it not the case that complaints are more likely in celebrity than non-celebrity cases?
No, there's lots of complaints about all sorts of cases.
Mr. Stummer, were I concerned that you had acted criminally in the course of your office, should I take that to the police or leave it to the Bar Standards Board?
You should take it to the police.
So why in the recent case, in terms of gender selective abortion, was the fact that there was a professional regulator, in that case a GMC, a reason for not prosecuting a case where you had a reasonable prospect of conviction?
I agreed last week that we would put a more detailed set of reasons into the public domain setting that out, which I intend to do in the very near future. My strong preference would be to put that out in detail before dealing with it piecemeal.
Well, perhaps you can just answer me one question of principle. Do you think it is in the public interest to deter gender selective abortion?
Well, I mean, that's a very general question. In this,
Can you answer?
in this particular case, one has to bear in mind that the legislation does not in terms specifically prohibit gender-selective termination.
So you don't want to deter it?
No, I'm not. Of course, there's a public interest in upholding the criminal law, and gender-selective abortion it would be prosecuted in the right cases.
But not in this case.
Well, that's why the detailed reasoning is important, because the facts are critically important, the basis upon which the prosecution could be brought, and the detailed reasons of the public interest. And I don't want to frustrate you, but I do think that having agreed to put fuller reasons...
Well, the reason why
public
Mr Reckless has raised it is that it was raised at Prime Minister's questions today.
Yes.
And there is a feeling that the CPS has not taken appropriate action because the policy is not clear, irrespective of the public interest. You can tell this committee today there is no question that if somebody decides to gender select, that would be unlawful. You would prosecute. Is that clear?
No.
What is the current position?
Just two or three things. What I agreed to do last week was to put detailed reasons into the public domain so that individuals could better understand our decision. I've been working on that, and I hope to do that in the very near future. That will then set out in detail what the facts of the particular case were,
right,
and why a decision was taken not to prosecute.
Leave aside that case, but because we don't know the case, and we understand you have to make decisions on the basis of the facts of each case.
Yes.
But as a matter of policy, is it unlawful for a medical professional to say, I will perform this abortion because this child is a girl?
If that's the only reason, it's unlawful.
It is. And how many cases like that have you all prosecuted?
I don't think we've had any to consider.
None at all, ever?
As far as I know, none. I don't think we've had to consider any other cases.
But in these cases that you have considered, you go back to the practitioner, do you investigate? Who investigates?
The police investigated.
The police investigate. So have you had any police reports on any cases? We just want to know how widespread this is.
Well, as I say, I mean, I will double check this for the committee, but as far as I know, and certainly in the last 5 years, we have not had any of these cases investigated and passed to us to take a decision on prosecution apart from these.
That's very helpful. And when do you think this policy will come out? Because as we know, you're about to...
No, it's not a policy. It's detailed. It's a detailed reasons, and I hope to get it out in the next day or two, which is the only reason, Mr. Reckless, that I'm. I mean, it's so close to. I'm so close to be able to provide you with a much fuller answer.
Would you send us once you put it into the public domain, just in case we miss it?
Yes.
Would you write to us and tell us about this? Because there is obviously great concern. But what you're telling this committee is that if anyone gender selects, you will prosecute.
If it is an offence to authorise a termination or carry out a termination, unless two medical practitioners, genuinely and in good faith, certify that the risk to the mental or physical health of the patient is greater by continuation than by termination. That's the test. The statute says nothing about gender or handicap or anything else.
And is that the problem?
So
should it?
Well,
because that would be
one of the things I'm going to deal with, hopefully tomorrow or the next day, but as soon as I can, is the fact that there isn't very clear guidance here. Now,
well, there isn't clear law.
But I will be. If the only reason is gender and it's got nothing to do with the risk to health, then in those circumstances it may well be an offence because the doctor would not in good faith be able to form the appropriate view. But the test is whether the doctor in good faith formed the view that set the view. But
you will make this all clear.
Because I understand the concern. I
understand the concern.
I understand the concern. I understand the debate. And it's for that reason that I think I do need to set it out in detail. And I will send it to the committee. I'll send it, Mr. Reckless, to you straight away when it's there. But I intend to deal with it and set out in clarity and detail what the position is and why the decision was taken in that particular case.
Mr. Summit, this has nothing to do with the decision you made in this case, because the CPS judgment was there was sufficient evidence for a realistic prospect of conviction. under the law, yet you determined it was not in the public interest. Why?
That is what I am going to set out in the fuller statement, so everybody can see it in the context of the facts of the particular case. I think the difficulty is that unless the full facts are there, there is concern about the decision that arrived at. And that's it is to answer that question that I will issue, as I say, sooner rather than later. I'm hoping.
Mr. Ellis, could you hold yourself, please? Mr. Ellis, order. Mr. Reckless is asking a question. Would you please let him ask his question?
Yeah. Are you concerned that the impact of the decision you made not to prosecute in this case that there will be a greater amount of gender selective abortion, and are you proud to have that as your legacy?
I would obviously be concerned if that were a consequence. I think when the reasons are set out in detail, people will understand that that's unlikely to be the case.
Thank you. Dr. Huppert has a question on cybercrime.
Thank you very much, Chair. We heard yesterday from the Information Commissioner about a range of issues with blagging, and it became quite clear, I think, that SOCA do not take computer-related issues, data-related issues very seriously. And I've had comments from a number of other people about that with Computer Misuse Act and Data Protection Act. Does the CPS take these issues seriously enough?
Yes, we do. I have to confess I really haven't kept up with the proceedings. If there was any evidence on this yesterday...
It's a general question rather than a specific one.
It's not specifically about other issues.
The evidence yesterday, I just haven't seen
You're convinced that the Crown Prosecution Service takes offences under the Computer Misuse Act, Data Protection Act seriously enough, that aims for serious enough prosecutions, and rates these in the way that they ought to be considered, because some of these are very serious crimes?
Yes.
Thank you. Michael Ellis.
Well, thank you. I am entitled, of course, to a comeback. Mr. Reckless mentioned my name before he went on about the other matter, and we are very close to a division, so I'm very keen to deal with a couple of issues. The first is, because we must have absolute transparency, I think, in this committee, and I want to make sure that we cover a couple of issues that have not yet been covered. So the first thing is, I want to make it clear, for my part, I mean, I've prosecuted many cases as a barrister before I was a Member of Parliament. I don't think that every time the Crown Prosecution Service loses a case that they've made the wrong decision to pursue a prosecution. I want to make that very clear. But clearly, there can nevertheless be pressure on any well-meaning individual in a case that has become a cause célèbre. Do you accept that that is at least a feasible prospect? It's not necessarily an improper decision or a decision made improperly to prosecute or not to prosecute, but there can be an increase in pressure one way or the other if a case has become a cause célèbre.
Well,
do you have any safeguards to protect your own staff from cases that might get more than the usual amount of public attention?
Well,
like not letting them read the newspapers.
Well, I mean, the whole point of the Code for Crown Prosecutors and the whole learning of the Crown Prosecution Service is to act with independence and integrity, and that means that you don't take pressure into account. And I can happily say that at no stage in my tenure has anybody ever sought to put pressure on me in relation to any of the cases that I've had to
I wouldn't have thought they would on you, but I'm thinking more of your more junior staff, your regional staff in regional offices, and so on.
Yes. So far as that is concerned, there are safeguards about the quality of our decision-making that are in place on a routine basis. Every quarter, we dip sample cases to ensure the quality is right, so that throws up random cases. Cases that are particularly high profile, sensitive or difficult are subject to very often a case management panel within the CPS where senior members of staff look at it. And of course, the principal legal advisor or I are consulted in a number of these cases.
Good.
Or we might go to external counsel. So there are all sorts of checks and balances.
Right.
But I do want to resist this notion that cases are pursued because of pressure. In fairness to my staff, they faithfully apply the code and arrive at a decision. They may well be criticised for it and held to account for it, and so am I, and that's absolutely right. But the fact that we give our reasons, which is something I've been very keen on in my term of office, go out and explain ourselves, answer questions about our decisions, if necessary put further reasons forward so that we can be even more transparent. That is all designed to show our workings.
Yes, quite right. And I agree with that. Now, can I move on and ask you about the so-called soccer list? And I'm not going to ask you to divulge anything, but I want to ask you something general, as a matter of general principle, which is that knowing what you know about the criminal justice system, do you think it is in the interests of justice for alleged offences, where there are some, or suspicions, to effectively to sit around for 7 years and for nothing to happen with them? Do you think that might be tantamount to an abusive process caused by delay?
Well, it depends on the circumstances, but the general proposition, it's not right.
Yeah. I mean, when you say it depends on the circumstances, of course, if prosecuting authorities, to give an example, if prosecuting authorities don't know all the facts and there's that sort of delay, then clearly there's no issue there. There's no fault there, or there may not be any fault. But clearly, where there is, or may be, some fact, then a delay is not of that sort, and that order is not conscionable, is it?
Well, hard to deal with in the abstract, but the case law is pretty clear. Delay is a basis for an abusive process argument. The court, if such argument arises, will look at the reasons for delay, and if it thinks that it is the failure of the prosecution to act properly, that counts against the prosecution in the abusive process argument, and courts will then stop a case.
Thank you. Mr. Ellis, a final question.
No, that's it from me, thank you.
Mr. Starmer, in response to inquiries at the end of last weekend, you said that the Crown Prosecution Service was reviewing evidence in regards to Millipede of police officers who may have accessed databases for private investigators. Is that correct? Are you involved in any way in any of the aftermath of Millipede? Have you asked for any review of any kind?
I've not been involved. Can I write to the committee and just clarify the proper position and put it to you in a letter?
But in respect of any of the activities concerning Millipede, is the CPS involved? Are you currently considering any proceedings?
Well, I think I'd rather put that in a letter, if I may.
Certainly. Very finally, you're off now. Like predecessors of yourself, they've gone back to the bar, some have become judges. I won't ask what you're going to do next, but what do you think your legacy is for the Crown Prosecution Service, which you have served so well over the last 5 years? What we have seen is greater transparency. We've seen your Crown prosecutors on television much more explaining decisions, as you've said. If you're very much alive, but on your tombstone, what would you like it being said of you as Director of Public Prosecution?
Well, I do think it's for others to decide the legacy of DPPs rather than DPP themselves. I mean, what I hope I've worked hard at is being much more transparent, being prepared to say up front how we will approach a problem by issuing guidance on difficult matters like assisted suicide and social media and child sexual abuse. So being clear up front, how do we address this problem? Then showing our workings by being prepared to give reasons for what we do and allow people to see for themselves what the decision is and to judge us and hold us accountable. I've often said I can't be held to account if people don't know why I've made the decision that I've made. And then I hope I've also introduced an element which is a willingness in the Crown Prosecution Service to look again at issues or decisions if there's any reason for concern about